Thanks for staying with us. The death of hip-hop artist Jabulani Tsambo, also known as Double HP, has brought issues around customary marriages to the fore. Now, the artist's partner took his family to court in order for her to be recognized as the rightful customary wife. For more on the issue, we have traditional and customary law expert Professor Thandabantu Nhlapo in Cape Town. We also invite you, the viewer at home, to call in and ask questions or share your experiences on this issue. Our number is 011 759 6340. That's 011 759 6340. So do give us a call and give us an idea of what your view is or what your experience is around the issue of a customary marriage. Professor, thank you so much for joining us this Sunday afternoon. Now, there's been a lot of talk around the issue of customary marriages, especially with the news of Double HP and his partner grabbing the headlines, as it were. Now, the Recognition of Customary Marriages Act was brought in 2000, and that really did make a big difference to the rights of both a husband and a wife. How much has the Recognition of Customary Marriages Act changed how we view the rights around customary marriages?
Well, thank you very much for having me. The Recognition of Customary Marriages Act is an extremely important piece of legislation because it changed the way that South African law regarded families formed by people who enter into family status via not the civil marriage, but in fact the rituals and processes of African law. So for the first time in South Africa, the customary marriage was recognized. There was also the fact that because this was coming during the democratic dispensation, one had not only to pass the law recognizing the way that Africans get married according to their own values, but also making sure that some of the things that happen within a customary marriage should be now in line with the Constitution.
Now, for South Africans who don't come from the tradition or don't come from the communities where customary marriages take place, many believe that all that needs to take place is that the lobola needs to be paid, and then that's it, a customary marriage is over. But it's far more than that, isn't it? Could you explain to us exactly what needs to take place for a customary marriage to take place and for it to be recognized?
Thank you again for that question, because it is extremely important. There is a lot of misunderstanding about the essentials that must take place before a customary marriage can be said to be valid. Let me try and set it out briefly. Since the 15th of November in the year 2000, when the Recognition of Customary Marriages Act came into operation, there are three requisites for a customary marriage to be valid. The first is that both parties must be 18 or over. The second is that they must both consent to marry each other according to customary law. The third, which is the most significant, is that the marriage that we are talking about must be negotiated, it must be entered into, and it must be celebrated according to customary law. To break that down even further, what this means is that there is a three-step affair. First of all, after the first two, 18 and consent, here the marriage must be negotiated according to customary law. Secondly, the marriage must be entered into according to customary law, or must be celebrated according to customary law. In other words, even though there is a statute now governing customary marriage, this third requirement of validity takes us back to the pre-statute customary law. So you must be able to have done the things that are required by your customary law for the marriage to be valid.
Now, the registration of a customary marriage at the Department of Home Affairs, how important is it for that to take place? Or may a couple decide not to have their customary marriage registered with the Department of Home Affairs?
In my considered opinion, it is not important at all.
Can you explain? Yeah.
I say that is again, yes, I will explain it. I had to put it sort of dramatically because it is important again to dispel another myth that a non-registered customary marriage is problematic. It is not. What happened was this. The South African Law Commission, in preparing the statute in 1998, after substantive and extensive research, found that Africans in general do not value the process of registration because in the culture of the people, marriages are always notoriously public affairs. So the argument that was made by the Commission was try and arrange for a law that persuades people to register, but you cannot penalize them for not registering. So Section 4 says there is a duty placed on the marrying parties to register their marriage, but Section 4 subsection 9 is explicit that when they fail, or if they fail to do this, it will have no effect at all on the validity of their marriage.
But do you believe that that has caused some confusion with what people think that they need to do to have their customary marriage recognized in law?
I do believe there is a level of confusion. I really don't think it is largely around registration. It is largely around the third of the requirements for validity. The problem with penalizing failure to register is that you would then, in the nature of things, be taking perfectly valid customary marriages and placing them in further jeopardy in addition to the previous apartheid and colonial failure to recognize them in the first place. And most of the people who are at risk when you don't recognize a customary marriage or where you place too many obstacles to recognition, the people who suffer tend to be the women and the children.
Now, if I could just ask you to pause there for a second. We do have a caller on the line who wants to make a contribution of some kind. Anonymous, hopefully you can hear me. Please do go ahead with your view.
Hello, how are you?
Very well, thank you. Please go ahead.
Yes. Professor, I have a question here.
Yes?
Yes. My brother was married, customary marriage, 2001. Then it didn't work out with this woman, and then they separated just like that because they didn't go on a magistrate to sign officially. And then he got married. Now he's married again. So our question now is that should he die, that wife has the right to claim that my brother's asset or what? Because, you know, my brothers took the route of lawyers so that they can make it officially around those 2001. Then the woman didn't appear on court. Unfortunately, my brother's lawyer passed away. Then they left. They didn't continue with that case. And the woman, before the lawyer passed away, the woman didn't show up on court several times. So my question is that on that instance, what must my brother do to avoid this confusion in the near future?
Okay, before I let you go, I just want to be clear on your question. Your question is around the first wife that your husband took, and whether, now that he is married to another woman, if the line hasn't been officially drawn underneath the marriage to the first wife, if that woman does have a claim legally, if something were unfortunately to happen to your brother. Is that the question that you have to ask? All right, I'll leave you there for now. Let's go to our expert. Professor Nhlapo, I don't know if you heard the gist of the query around the rights of the first wife in a customary marriage as opposed to the second wife, if they're not entirely sure whether that first customary marriage has been brought to an end legally. What do they need to do to ensure that that is cleared up?
Let me confess to a problem here. I can't hear a thing. It's very loud in my ear.
Okay.
So I wonder if you could repeat the question.
Okay, sure, Professor. We had a lady who called in, and the question was around her brother. Her brother had married a woman under customary law in 2001. They then separated. She is not sure whether a line had been drawn underneath that separated marriage because the brother's lawyer had passed away and the woman failed to show up in court. And it's, according to her, it was left at that. But the brother has now taken a second wife. And they are worried that if something were to happen to the brother, that the first wife would still have a right to claim property or any assets, because they are not sure whether that first customary marriage had been brought to an end legally.
Okay, I think I get that. And it raises a number of very intractable problems attaching to the Recognition of Customary Marriages Act. Under normal circumstances, a customary marriage is entered into by the two families of the parties involved, and that is where the contract is struck. When you want to undo that contract, you undo it by reversing the same process of negotiating the marriage. This time, you negotiate the termination of the marriage with all sorts of issues involved, including return of lobolo and so on. And the Act introduced in Section 8 something that was new to customary law, which is that the marriage now has to be dissolved by the High Court.
Okay, fascinating. I do hope that that has been of some help. Go ahead.
Yes.
Sorry, go ahead.
Hello?
Yeah, do go ahead, Professor. I'm sorry, you still had something you wanted to add.
Oh, yes. Yes, I did. The problem with this is that, again, we have created a number of what I call twilight customary marriages, because people are continuing to terminate them by negotiation without bothering to go to court, which was an innovation that was alien to the culture they understand. So you have marriages where the parties, according to their reckoning, are terminated, where the marriages are terminated. But in South African law, because these were not terminated in a court, they are in fact technically still in existence, which does mean that the questioner or the caller may have the problem not of bigamy, because of course the brother can take a second wife. Polygamy is allowable in customary law. But the point of the matter is that there would be doubt whether the marriage to the first wife is terminated.
Okay, indeed, fascinating stuff. Hopefully that advice would have been of some help to that caller. We have another caller on the line, Katlego from Pretoria. Thank you so much for joining us. What is your contribution?
Hi, my question is around, say, people who are married, and then the husband has denied a child. So when he passes on, I want to know if the children that he's denied, are they going to be entitled to his
properties or monies or anything like that. The kids that are not declared as his kids because he has been denying them, but when he passes on, does his wife have the power to deny everything or to fight against these children benefiting from his assets or properties?
Okay, I think I've got the gist of that. Thank you so much for your call, Katlego from Pretoria. Professor, I don't think you can hear the callers. The question there being that if somebody has been married in customary law and children that he's had outside of the customary marriage, and if something were to happen to the so-called father or the husband in that marriage, what claim do the children outside of that marriage have on his assets, and does his customary wife have the right to deny any inheritance to these children that her husband had so far denied as being his own?
Okay, there is again a very strong cultural element to this. Generally speaking, and I should stress that I am generalizing, there are good legitimate grounds for that because there are commonalities across most customary law systems in South Africa. But very generally speaking, extramarital children, I'm using that in a anthropological sense.
Indeed.
According to our constitution, you can now no longer discriminate on the basis of illegitimacy. But children born outside of that customary marriage, several steps may need to be taken. According to some customary law systems, and the one that I know best, because that is the one that formed the subject of my academic study, the Swazi. According to the Swazi, it would be quite possible to affiliate these children into the family of the husband or the progenitor, the biological father, by arranging with the parents of the mothers of these children, if they are different, to pay a certain level of what you might call a kind of damages, but in Siswati inkomo tekutsenga umntwana, cattle to buy the child, of course it doesn't mean purchase. You can affiliate them in that way, and your wife in culture is going to become their mother to all intents and purposes. On the other hand, if it does not do this, a child that is born out of wedlock belongs to the guardianship and custody belong to the father of the mother. In other words, their paternal grandmother. So the inheritance rights of those children are either going to be with their biological father, this married man, if he has done the right thing, or if he has not. For instance, according to this was one of the ways of losing your rights over these children would be to deny paternity when the pregnancy is reported to you, because that's an insult to the mother. So the inheritance rights are between their paternal grandfather's home or their biological father's home.
I suppose a follow-up question for me would be, if in this case both the father denied that those children were his and his customary wife continues to deny that those children are his, what is left for those children to do? Do they need to do a DNA test? Are those kinds of paternity tests accepted as evidence under customary law?
Let me understand you correctly. Who denies who denies these children? I'm assuming that you are saying
both
the married man.
Yeah, the married man as well as his customary wife have denied that these children are his. What can they do?
And well, as I was saying, if he does not acknowledge them, then for a start, what I said about affiliating them will not happen. But also, he then runs the risk of losing any contact and affiliation with them, even if he changes his mind later, because then their rights will lie in their paternal fathers, their paternal grandfather's place as part of his family. The customary law philosophy here is that no child should remain in a state of not belonging anywhere.
Okay.
So it's very clear that if the father denies them, the grandfather is the one who is their family.
Okay, we've got another caller on the line. Madeline is on the line, and she has a question as well. Madeline, do go ahead. Madeline, are you still with us? Would you like to ask the professor a question? Okay, let's try another caller. We've got Donald on the line. Donald, you have a question for the professor?
Hello?
Do go ahead.
Okay, I just wanted to ask the professor one question.
Sure.
I want the professor to clarify for us the differences on other marriages besides the customary law.
Okay, if I understand you correctly, Donald, you want the professor to clarify the differences between other marriages. Do you mean civil marriages?
I mean civil marriages.
Western
the question is, I want to know if our African culture is being sidelined in this case, because the other laws, the other marriages, obviously, according to the laws, are being recognized. So I just wanted to know where this stands according to the customary law as Africans. How does it affect us? Because obviously, if I check with the case of Triple HP situation, it has become tricky that the in-laws doesn't want to recognize her or that thing. So where do we stand as Africans according to our customary laws? Are they being recognized, or are we being engulfed by the white monopoly capital that they are only recognizing the other types of marriages that suit their needs? That's the question.
Okay, Donald, thank you so much for that question. He even brought white monopoly capital into the question. Donald is wondering whether there's too much of an emphasis in South Africa as an African nation on the importance or I suppose the hierarchy of marriages, in that civil marriages are seen as more recognized as customary marriages, and what kind of impact that has on the upkeep or the holding up of customs like marriages in the African tradition. What impact do you think that is having, Professor?
Okay. Yes, thank you. I think the caller expresses a concern that is quite widespread. I do not have as pessimistic a view as that. The Act of 1998, the Recognition of Customary Marriages Act, really did change things quite drastically. Customary marriages are fully recognized. Customary marriages have come out from under the shadow of the civil marriage. In apartheid times, they were so under that shadow that if a man married one woman by custom and another by civil rights, the customary marriage was actually extinguished by the civil marriage, and leading to that very sad and sort of backward situation where you had the phenomenon of discarded wives. All of that is gone. The customary marriage is fully recognized. The only difficulty that I see, and the case of WHP actually brings this to the fore is that there are two problems. One is the difficulty with ascertaining whether a valid marriage has now been concluded is in a state of flux because the courts have been attempting to work through a slew of rituals and processes that have to take place when families bond together to become in-laws and decide which amongst these many requirements are the essential ones. And that has enabled families, particularly families of the husband, when he dies, to deny wifely status or daughter-in-law status to the woman their son leaves behind because they challenge everything in about 6, 7, 8, or 9 steps that are taken. So I believe that the solution eventually is going to have to lie in the courts bringing the whole thing back together to favoring certain essentials over others and classifying others as less relevant or less key, which is what Justice Mokgwatleng did, in fact, in the HHP matter. He, looking at a number of things that are always claims by Africans that are supposed to be done to marry, there are a lot of them loopholes in denying the marriage if it is in the interest of the denier. So that's one of the problems. Now, but generally speaking, the marriage, customary marriage, is as valid as a civil one.
Before we take our next call, we've got Godfrey on the line from Guyana. I'm not going to take him just yet. I just have a follow-up question on this issue around double HP and his partner, Lerato Sengadi. Now, we're told that that case is far from over and that the family would be appealing the decision handed down by the judge. They say, I believe the statement here was, as a family, we believe his judgment was not properly considered. We have specific ways in which we define customary marriages, and that will be spelled out in our appeal. There's no way those processes were met. Now, there might be people watching that are sitting in the same position. In your view, what are the things that you need to be able to prove that you are indeed the customary husband or wife of another person in a court of law?
Right. I think that is the key question, the key question of this discussion. Let me again try and break that down for you. If you consider, just taking the Nguni group, that when a young man wants to marry a young woman, let us say, he goes to his parents, his father is supposed to put together a delegation to go to the woman's people to ask for the hand of the woman in marriage. Then that leads to the discussions, and they are usually discussions about lobolo. Then that leads to a firming of the amount of lobolo and the terms on which it is going to be paid. And then usually follows a ceremony, a small one, the slaughter of small stock, a goat or a sheep, to accept or to mark the coming into existence of the lobolo agreement. Then there is the payment. Then there is the wedding and so on. The things I've counted are already about 5 or 6. There are even more if you add pre-lobolo, like in Vulamloma and so on. The point I'm trying to make is this. There are many processes, and so far the cases that have been decided since the democratic dispensation seem to say that the two factors that swim up to the surface are the negotiation of lobolo with all of the various things that surround that, the agreements around it. And let us be very clear, it does not have to be paid in full. This is just another of the loopholes that are used to deny a marriage. In African custom, mostly the agreement is the crucial thing. It has been known for people to be fully married for a whole lifetime and live a rich life and be known by their neighbors and society to be married with not a single cow or a single cent having been taken over. So much so that the fellow, when his daughter gets married, he uses the lobolo paid for his daughter to lobolo her mother, to pay lobolo for her mother. So let us get off this idea that full payment is required. If it doesn't happen, there's no marriage. So the courts have come at least to that conclusion, that lobolo must be negotiated and agreed, doesn't have to be paid in full. Secondly, what has come to the fore is that some way of what they call the handing over of the bride must happen. It's not a phrase that I support. I don't think it's handing over. It is that sort of influenced very much by Western thinking, like a father walking the daughter down the aisle in church to hand her over to the husband. The better phrase is the integration of the wife into the family of the husband. Now, that is still considered as important a step as the lobolo arrangements, except that in the decisions that have taken place since 1994, since 2000, since the Act came into being, it is now accepted that this can be inferred from behavior. And I think that was the problem in HHP's case, or at least the claims of his people. The judge was saying it is not a requirement. I think more careful language would have said it can be, it is a requirement, but it is easily satisfied by looking at the lifestyle of the parties. And so cohabitation, for instance, giving them a reputation in society as being married counts a lot to qualify as what some judges have called constructive handing over. So it comes down to those two.
Okay. Very fascinating. We've got time for one last call, and we thank you so much for holding on, Godfrey. We're sorry for keeping you waiting. We had some very important issues to clear up with the professor. Godfrey from Guyana is on the line. Do ask your question, please.
Thank you for being with me here. I want to ask Professor, I've married a woman. This woman, when I married her, like I've sent people to go and pay lobola, and then they paid lobola for her, and then the lobola was completed. Actually, what I mean, I paid cash. So what happened was the parents did not, and this lady had 2 children, to which she was married twice before I married this woman. And now what I want to understand is, these people now, when I went to them, I asked them why the wife is not coming back home and all that. And the children that I've married, they just answered me like they say, the children cannot bring themselves to your place, and then they must be brought to you. Then I had to keep away. And now it came to a point where I realized that this woman that I've just married, she's in love to another man or 2 or 3 men, in which these people, she decided not to come to my place anymore. And then she left after I married her in 2008. In 2009, then we were blessed with a boy. And then she left this boy when she was 2 with me, and then she left for another man, and she stayed there. And when the son was 7, then they came here, they claimed that I've abducted the child, and then, the police is looking for me, high and low. And then when they realized that they failed with the police, then she went to the lawyer and said to the lawyer, okay, right, I got a summon, I had to go to court. Then I remained with this child from 2 years. And then the child was raised by me, and then in the 7th year, when he was starting school, they just came and took the child. And then they removed the child. This child was from school, And then they came, they came to the social workers and they said, okay, right? I asked a question. I said, what is going on when you don't want to be in your own home where you are married and then we don't owe your parents anything? Unfortunately, there was no delivery of a woman into my house. So in that stage, what is going to happen in the case when I'm dying? Because I've got another wife that I had before, and to which we were also married in community of property. So I just want to understand what is going to be going on thereafter. If maybe perhaps if I die now.
Okay, Godfrey, before you go, I just want to clarify with Godfrey before he goes. You want to know what your rights are as the father to that son, and now that the woman who has left you has left and is now claiming the son, and what will happen to inheritance or your assets once you were to die, and whether your current wife would have rights over it, and where the son and the son's mother fits in. Is that the question that you're asking?
And the son's mother. Is that the question that you're asking?
Yes, moreover, that before I continue to just leave, by the time when she went to court, when they decided they want to have the child, she claimed in the court papers that I was his boyfriend, I was not his husband, and now I abducted the child. Oh. And then when I delivered the child, the magistrate, I said they must come and collect the child because the order said I must deliver the child and change the surname from my surname to her surname. So if I've got to change my surname to her surname, whose child is that one? And then I decided to ask the social workers to make a DNA test. Instead of making a DNA test, what happened is they went to court and they went to court and they just issued what you call the judgment and said, this is I must deliver the child to the woman, and I must sign the document that this child belongs to the Macabas, and then and at the same time they didn't bring back my money that I've paid with it.
Okay, Godfrey, I'm going to have to cut you there because we are running out of time, and let's see if we can get the Professor's input. Professor, did you hear the gist of Godfrey's query? It does seem very emotional, and he's filled with angst. What is your advice?
This time I did, yes.
Great. So what is your advice to Godfrey? He's very anxious.
Yes, and I think he's, what the English would call, he's being diddled. Indeed. I wanted to use a stronger word, but I think I will not, this being a family program.
Indeed.
The child in customary law is his. Lobolo has sometimes been called not bride price exactly, but child price.
Indeed.
Because it lays claim to the fruits of the womb of the wife. What would have been an expected process for him to have followed would have been to divorce the wife with whom he was having these difficulties, and in custom that would have led to an assessment of who is to blame for the termination, and that might well have accounted for the assessment of whether the lobolo that he has paid is enough for him to lay claim to his own child. But my sense is that that is his own child and he is being diddled.
So what would you advise me? What should he do?
Unfortunately, that's what I was going to say, that the difficulty with parallel cultures and parallel lives, as it were, is this business of customary law and customary processes now having to work hand in hand with courts and lawyers. But my advice is that, unfortunate though it sounds, he needs to get a good lawyer to fight the customary law case. I think he has got an absolutely unassailable customary law case to the to be affiliated with his son and his child and to keep his child. If there were to be a divorce, he may well also be entitled to some return of lobolo.
Okay, we're going to have to leave it there. Professor Thandabantu Nhlapo, thank you so much for joining us. I do believe you should start a helpline because I think a lot of people have benefited from your advice this afternoon, and we thank you for your time from Cape Town. Thank you so much.